Welcome to the InfoBrokerWorld podcast, where business intelligence meets global strategy, empowering entrepreneurs with the insights they need to stay ahead.
Registering a trademark is only the beginning of protecting a brand. What really matters is what happens afterward, keeping that mark alive, distinctive, and free from conflicting claims. In today's fast-moving global markets, unauthorized uses can come from anywhere: counterfeiters, opportunistic competitors, or even well-meaning businesses that didn't do their homework. To stay safe, companies need two things: constant monitoring and a clear strategy for enforcement. The first line of defense is monitoring. This isn't just about watching national trademark registers. Serious brand protection means scanning worldwide filings, checking domain registrations, and keeping an eye on online marketplaces and social media. Early detection is everything. If you catch a problematic application before it goes live, you can stop it cheaply and efficiently. Wait too long, and the cost, both legal and reputational, rises dramatically. If a conflict shows up during the publication of a trademark application, the tool of choice is opposition. An opposition is a formal way to say, "Stop. This mark is too close to mine." The grounds are familiar: likelihood of confusion, earlier rights, bad faith, or lack of distinctiveness. Deadlines are short, sometimes only a month or two, so speed is essential. In Europe, there's even a built-in cooling-off period to encourage settlement before the dispute hardens. A successful opposition can block the application entirely or limit it to certain goods and services. But what if the mark is already registered? In that case, the focus shifts to invalidity or revocation. Invalidity wipes a mark out from the beginning, as if it were never registered. This can happen if the mark was generic, misleading, or filed in bad faith. Revocation, on the other hand, comes into play later, if the mark hasn't been used for years, or if it has slipped into common language and lost its distinctiveness. Think of once powerful marks like escalator or aspirin, which became generic over time. Not every dispute needs to reach the courtroom. Cease-and-desist letters are often the first step, signaling the seriousness of a claim without immediately escalating. In many cases, businesses negotiate coexistence agreements, setting clear boundaries for how, where, and on what goods the marks can be used. Sometimes a small tweak to a logo or name can resolve a conflict entirely, avoiding bigger battles. Of course, when diplomacy fails, litigation may be the only option. Civil lawsuits allow brand owners to seek injunctions, damages, and even destruction or recall of infringing goods. In the most serious cases, especially with counterfeiting, criminal charges may also apply. Customs authorities can be powerful allies here, intercepting fake goods before they hit the market. Technology is transforming this space. Artificial intelligence now monitors vast amounts of data in real time, spotting look-alike logos, phonetic similarities, and even conceptual overlaps across multiple languages. AI can gather evidence, flag high-risk cases, and even predict how disputes might play out based on past rulings. It can generate takedown notices automatically and scan e-commerce platforms for counterfeits. But AI has limits. It may miss cultural subtleties, linguistic nuances, or the human perception factors that matter so much in trademark law. That's why expert legal counsel remains indispensable. Trademark lawyers don't just handle filings. They guide strategy, weigh risks, and make the call between fighting, negotiating, or rebranding. They know the procedural traps, the deadlines, and the arguments that work. And in international business, where each jurisdiction has its own rules, they are often the difference between success and failure. In the end, securing a registration is only step one. Protecting a brand requires vigilance, quick action, and the right mix of technology and human expertise. Companies that master this balance, combining AI-powered monitoring with seasoned legal judgment, are the ones that preserve their identity and lead the market.
Thank you for listening to the InfoBrokerWorld podcast. If you have any questions about today's topic, feel free to reach out via the contact details in the show notes. This podcast was created using AI tools. If you're interested in producing your own AI-driven podcast, from concept to audio, feel free to get in touch. We'd love to hear from you. Until next time, stay informed and stay ahead.